Hello. Today we're going to talk about maritime employers liability and subcontractors. Now, for the rest of this talk, I'll just refer to maritime employers liability as MEL because it's easier to say and, well, we don't have a lot of time. Subcontractors, I'm going to speak generally about subcontractors, but this can include any of the various kinds, 1099s, individual subcontractors, individual LLC subcontractors, some small subcontractor companies, foreign local nationals, and others. But we're going to talk generally speaking about subcontractors, and these apply to all the various kinds. So let's start out with the easy question. What is MEL? Now, MEL is a kitchen sink of coverages, providing coverage for general maritime law, including maintenance and cure, and unseaworthiness, transportation, unearned wages. For most forms, you can endorse Death on the High Seas Act, and wrongful death, and MEL provides coverage for the Jones Act. Now, oftentimes you'll hear Jones Act MEL coverage referred to as Jones Act, and that's not incorrect. It's sort of like calling McDonald's a hamburger restaurant. It doesn't tell the full story. They do sell hamburgers, but it does not give you the full breadth of what they do. Now, Jones Act coverage is a big part of the MEL policy because it is the most high benefit levels and high litigation areas for MEL. So most of what we're going to be talking about is Jones Act exposure and how the MEL policy covers that. If you've been to one of my talks before, you've seen this picture, and we're going to be talking only about the employees in number 3 and number 4 and how we cover them with the MEL policy is listed as bracket C here. Now, you can also cover these as P&I crew. That gives you the same benefits and same coverage. It's just structured differently. And subcontractors come up much more often in MEL than in P&I with crew. So we're going to talk about it from the MEL focus because how to structure that coverage is much more of an MEL focus. All of these same exposures exist regardless of whether or not you cover them with a P&I with crew or an MEL, or don't cover them at all. The exposure is there regardless of the coverage. Now, for the Jones Act, we have a simple 5-part test, and it's a connection to the vessel and navigation in the course of employment. The employee contributes to the function of the vessel, substantive connection to the vessel, and the vessel or is a part of an identifiable fleet. Now, that's a simple test. What does the Jones Act say? Now, for record, the Jones Act is what we call it. It's actually called the Maritime Marine Act of 1920. And it says, a seaman injured in the course of employment, or if the seaman dies from the injury, the personal representative of the seaman may elect to bring a civil action at law with the right of trial by jury against the employer. Now, before 1920, seamen didn't have the right to sue their employer. And this act brought that right to those employees. Now, this was pretty liberal stuff at that point in time, giving seamen the full recovery of railway employees was giving them the very highest benefit levels available. So, we're going to highlight one of these sentences. Injured in the course of employment. Now, that's a very key and very specifically defined phrase. Now, I'm going to set this off with one quick warning. I did not go to law school. None of this is legal advice. This is insurance advice. And for any of you who did go to law school, I apologize for the way I'm going to describe these cases, as I didn't go to law school and I didn't have the opportunity to learn how you guys say things. That being said, we read a lot of court cases in this office. We look at what these mean, and we take the interpretations as the courts have run them, and take our insurance advice from that. So, we're going to talk about a Supreme Court case called New Prime Inc. versus Oliveira. This was a 2018 case, came back last year. Oliveira worked for Prime as an independent contractor with an LLC. So Oliveira had an individual LLC as a subcontractor. And the real points of the case aren't particularly necessary. The main argument is what is focused on, and it's whether or not the Federal Arbitration Act of 1925 applies. And this is all hinges on whether or not contracts of employment applies to independent contractors. And this is directly from the case. And if you actually look at the Federal Arbitration Act, it actually gets more specific than that. They are talking, the Act says contracts of employment of seamen. And contracts of employment of seamen are excluded from the Federal Arbitration Act. None of this applies to that. So that was the basis of the argument, and they're talking about the contracts of employment. And from the opinion, we have at that time, the contract of employment usually meant nothing more than an agreement to perform work. As a result, most people would have understood that in the Federal Arbitration Act of 1925, to exclude not only agreements between employers and employees, but agreements that require independent contractors to perform work. So the Federal Arbitration Act doesn't apply in this case to New Prime versus Oliveira. But what they're saying in this is that contract of employment does apply to independent contractors to perform work. So what we have is independent contractors were in employment. We take this with what we had before with the 5-part test of the Jones Act and get rid of all the other ones. We're going to assume for these cases that we're going to talk about all the other ones are easy. It's just an independent subcontractor that we're looking at. We have the test being course of employment, straight from the Jones Act text itself, and independent contract. And now we have New Prime versus Oliveira saying independent contracts are in employment. So taking those two together, the independent contractors can be your Jones Act responsibility. Now, this is an easy one. For those of you who live in the comp world all day, this is an easy. The bubble up principle is written into the Longshore Act. It's written into comp as a whole. So this is not a foreign topic from that side. For the Admiralty, we have at LIG have had a long-standing concept that they could be, but this is the real first time we've seen real definitive evidence tested through the Supreme Court that they would likely be your Jones Act responsibility. Now, I am not suggesting that this is an automatic and that this is solved law. I'm not suggesting that. But what I'm saying is that this is definitely worth at least a few tests. And I hope I've made the point that even if you disagree with the logic in this, you see that the need to cover them, regardless of whether or not you think they will get the benefits, is definitely there. And as we see an increase of the subcontractors and independent contractors being treated more like employees, as you see with Uber and Lyft and the California laws that are coming through with that, this is definitely something to cover. Now, I hope I've made that point, and I've convinced you to just get it covered at this point. So, I've stated the problem. Now, how do we cover it? Now, I'm going to give you 4 different recipes. These are the 4 most common recipes that we use in this office to get this coverage. These are not the only ways. There are other ways. These are just the 4 most common that I use. So, option 1. For subcontracting companies, you have subcontractor buy an independent policy. You just tell them to buy their own MEL policy and check the certificate. Now, with that policy, make sure you have an additional insured or an alternate employer endorsement. Now, I know there are a few underwriters on this call, and I know that every one of them has an opinion about whether or not an additional insured or an alternate employer is more applicable. I will say this, looking at enough of the forms, I cannot conclusively say which one is going to be which and which one you need. I generally will accept either one as providing the right coverage, as long as the underwriter is trying to create the coverage for the parent company and the insured is disclosing about that. I don't think it makes much difference. That being said, I've seen additional insureds that look more like alternate employers and vice versa. So it's tough to tell by the name of the form alone which is which. Now, when you are looking at this subcontracting company and their certificate, first thing to check is the limit. If they're getting their MEL policy from their work comp employer or work comp carrier, it is oftentimes not $1 million limit. And you want to be aware of that because Jones Act cases are very expensive. They are just expensive. Of course, check the effective dates. Check the navigation limits. Again, with the work comp carriers who dabble in MEL, oftentimes they're restricted by NCCI rules to 12 nautical miles outside the U.S. So if you have an employee going well away, they may not have the MEL coverage for exactly when their job kicks in and becomes dangerous. Now, getting each subcontractor to get their own policy can be expensive because for a lot of them, they may only need this a little bit and they may run up against minimum premiums a lot. So this is one of the ways that this can get expensive. So option 2, you endorse the subcontractor corporations as additional insureds under your own master MEL policy. Now, the pro is on this one that the insured and you control the coverage. Now, it's difficult because you have to convince your underwriter to do this. You have less control over those subcontractors than you do your direct employees, as by nature of subcontracting, but their history goes on your loss history. And so it can be more expensive if you have losses in there to include theirs versus not including it. Now, make sure, the one gotcha we see of this, make sure to limit the coverage to your client's exposure only. Now, this means including something where it limits them only when they're working on behalf of parent company. That's how I normally do it. It's one of those gotchas, and make sure you have that full story with your underwriter. Option 3, for individual subcontractors, you can just include them in your policy. Oftentimes you have to craft some sort of wording to include those specific people, either by naming them or coming up with some definition to change so that they're included in your employee base. Oftentimes this includes the audit at the end of the policy year, includes their entire subcontracting costs, not just their payroll, as it's a better approximation of the risk. Again, this goes on your loss history, and again, you have to convince your underwriter to do it, and some just won't. Some read the word employers liability and think subcontractors don't apply. Now, that may be a very literal definition of the word employers liability or maritime employers liability, but they may not have seen this New Prime versus Oliveira, so they may not see that employers liability and MEL and Jones Act are all interrelated in this way. So hopefully that is going to be an easier thing to do. But again, it is you bring the cost in, and we have seen some people nervous about this from the client standpoint because it brings that bond tighter between the individual subcontractors and the employer. And if they're trying to keep that arm's length relationship between employer and subcontractor, then this is the problem. Now, option 4, subcontracting companies / individuals. Now you can cover these with their own package policy. So you buy one independent policy for the subcontractors. All the subcontractors work from the insured. Now, this is really interesting because you can control it. It can be a mix of companies and individuals. So you have the individual subcontractors, the subcontracting companies. you can really get creative with this one. This is some magical stuff when you do it right. Cons are you really got to understand, convince your underwriter on this one, because not all of them get that this is something where the parent company has that vested interest in insuring, but doesn't want to hand it off. So this is one where it's a tough sell, but when you get it, when you're in the right conditions, this can be perfectly good. You have the lower control over them, and this probably is the most expensive upfront, but you have the opportunity to manage that cost by managing the losses independently. And if you have subcontracting companies that are doing the more or less dangerous work, you can vary the rate between the subcontracting policy and the main parent company policy. And so that gives you some flexibility and checking. So, in summary, subcontractors are probably your responsibility to cover when it comes to admiralty exposures, particularly the Jones Act. And there are several ways of covering them, depending on what the insured's goals are and how the structure of the arrangements are.